Welcome everyone to our annual Supreme Court term preview. I'm Irv Gornstein, Executive Director of the Supreme Court Institute at Georgetown Law. Before we get started with today's scheduled program, I want to take the opportunity to acknowledge the passing of Justice Ginsburg. She was a trailblazing civil rights lawyer, a giant of a jurist, and a larger-than-life human being. But what I will remember most about her is her indomitable spirit. That and the devastating series of questions she hurled my way at oral argument in the Lilly Ledbetter case, in the kindest way possible, of course. At this time, I want to invite any panel members who wish to do so to say anything they would like about Justice Ginsburg. But first, let me introduce our panel. Don Verrilli from Munger Tolles, Paul Clement from Kirkland and Ellis, Nicole Saharsky from Mayer Brown, Roman Martinez from Lathan and Watkins, Paul Smith from Georgetown Law, and Marty Lederman, also from Georgetown Law. So anybody who wants to should be on video and take the floor. Anyone want to start? Don?
Yeah, so I'm still trying to get my head around the idea that Justice Ginsburg won't be on the bench any longer. I think for most of us, maybe all of us on this panel who have argued in front of the court, maybe, I don't know if this is true about you, Paul, but I think for the rest of us, she's been there for every argument that we've made on the court. As you said, Irv, in your introduction, even when you ultimately got her vote, she would always put you through your paces with that sort of insistence on exactness and insistence on getting things just right. I think all of us, whatever we think one way or another about her understanding of the law, have to admire so deeply her work on the court in these last few years, to have been able, given all that she dealt with physically, to be as active and vibrant a member of the court up to her very last day is, just an awe-inspiring thing, and helps explain, I think, why she was such a giant in the law and achieved as much as she did. Someone with that kind of fierce determination, combined with the kind of intellect she had, really, I think we were all lucky to have been before the Supreme Court that included Ruth Bader Ginsburg.
Thank you, Don. Paul Clement?
So thanks, Irv. And, like everyone else, still sort of processing all of this, but I would just echo a couple of your comments that both Irv and Don have already made, and then add one or two of my own. I was in the courtroom with you, Irv, when you argued the Lilly Ledbetter case. So I remember those questions well. You were too modest to mention that you prevailed in the case and precipitated one of her most famous dissents from the bench that in turn prompted congressional action, which is all part of the remarkable sort of leadership and that she provided the court's liberal wing, especially in her last years on the court, and really, had such a broad view of, her role and her ability not just to sort of, win cases in court for her side, but also to, in a case like that, to prompt a congressional reaction. That was all a remarkable case. To Don's point about her dedication to her craft under, difficult physical circumstances, I mean, I will, it was a privilege to argue in front of her every time she always based on her just arduous work habits, put you to not just through your paces, but made you a better lawyer. I mean, because if you didn't know the record backwards and forwards, you knew she would. So it definitely kept you working hard late in the night, getting ready for argument, because you knew she was working late in the night, getting ready to ask you questions, including potentially about things lurking deep in the record. But, you know, just to encapsulate that, you know, the last time I argued in front of the court with her on it, she asked me her questions literally from her hospital bed. And in the Little Sisters case, which of course was made possible by the telephonic format. But you know, what an image that somebody was so dedicated to her craft and her role that she literally was asking questions from her hospital bed, and difficult questions to answer, I should add, which is consistent with the way she always asked her questions at the bench. But then let me just finish with the last piece, which is what has really struck me, especially in the last couple of days, reflecting on this and reading all of the tributes to her and the like, is as long as she served on the court, I mean, decades of service on the federal bench, if you include her time on the DC circuit, she never lost sight of the fact that she was an advocate, and she never lost the sort of advocate's sympathy for what the advocate was going through and the challenges that the advocate faces. And that's why, Irv mentions the Lilly Ledbetter case. I certainly had a few of my own where she was definitely not with me. And she was asking very hard questions, but she was asking them in a very, firm but polite manner. There wasn't an edge on the questions. I mean, they were firm, but they weren't so sharp-edged that they left a scar. And I think all of that kind of goes back to the fact that she was an amazing advocate. She was an advocate who, was not just skilled in the courtroom, but was skilled in coming up with the broader strategy. If you go back and think of, her cases in support of equality for women, I think about half of them that she argued herself involved males as the plaintiff, as the litigant, all in, part of her craft. And, I just think it's remarkable for somebody to serve as long as she did on the court behind the bench, but not lose her sympathy for those of us on the other side of the bench.
Thanks, Paul. Nicole.
Hi, everyone. Happy to be here today. So I've talked to a lot of people, reporters, et cetera, about, who ask questions like, what was it like arguing before Justice Ginsburg? And, for the most part, like Paul and I think Don said, she played it straight. Her questions were straightforward. They weren't slanted one way or another, and they were clear. The thing that I always liked the most, and maybe this is because I was an assistant to the SG as opposed to an SG, was that she always used our names. She said, Ms. Saharsky, I have a question for you. And I thought, wow, she knows my name. I couldn't say that about all the other justices necessarily. Sometimes I felt like when an assistant to the SG went up to argue, we were all interchangeable cogs to them. But especially to have someone like Justice Ginsburg, who was such an icon, wow, she knows who I am. And then, she wrote the opinion in my first case. She wrote the opinion actually in many of the cases I argued. And I just considered that a great honor because I felt like, oh, she thought our briefs were good. She liked the argument. She wrote the opinion. That meant a lot to me. And I think, more fundamentally, just as I think back on it, I really am in awe of how she was willing to proceed through such difficult times, with the women's movement and proceeding incrementally to bring cases to the Supreme Court at a time when I think people wanted to proceed faster. And I think when it might have been frustrating to see some of the first women's rights cases before the court involving the rights of men. It's certainly not, what everyone else wanted to do, but I feel like there was a lot of wisdom in that. And it's something that I think about now just because, the last few years, at least from my perspective, haven't been the greatest in the US for women. And thinking about what comes next, I feel like we have a lot to learn from her. So I'm very grateful for that.
Roman.
Thanks, Herb. And thank you to Georgetown for having me and having all of us here. It was quite a shock when getting the news. I'm someone who came of age and really started following the court and learning about the court in the 90s and the early 2000s. And, over the last few years, we've lost, three giants of that sort of era with Justice Scalia and Justice Stevens and now Justice Ginsburg. Obviously, as an advocate and as a justice, her contributions were enormous across a lot of areas of law, most importantly, I think, in the realm of the Equal Protection Clause and expanding the guarantees of equality to women. As a law clerk, when I was at the court, the thing that impressed me the most was just watching her up close and personal and watching her relationship with the clerks. And she just had a sort of indomitable spirit and work ethic. She had these 4 20-something lawyers just scrambling, trying to keep up with her at all hours of the night as she was sending drafts around. She was going through health issues that year, and she also lost her husband that year. And yet, despite everything that she was going through, she just remained the total professional, the perfect colleague, and a person who was just actively contributing and leading on the court through everything. And I think she was a real role model. I think the only other thing that I'll just comment on was I think Justice Ginsburg, obviously in the last few years, had taken on a sort of a broad cultural relevance that goes beyond a normal Supreme Court justice. And I saw it in my own house when we got the news on Friday night. I have a 5-year-old daughter, and she, of course, has the children's books, the RBG children's books. And, she took it very emotionally. She took the news because what she knew about Justice Ginsburg was how Justice Ginsburg had helped. As she said, she took a hard path. I think she meant everything she had learned about Justice Ginsburg, becoming a lawyer and triumphing in the court as an advocate and then becoming a justice. And I think having someone who is a role model and a trailblazer, it's the one, maybe the one comfort that we have that she's gone is that I think her legacy is even more secure, and the inspiration she'll give to all of us, but especially maybe to young women like my 5-year-old daughter, I think will live on. And so, it is a very tough, unexpected, and very sad period because of that.
Thank you. Paul Smith?
Thanks, Irv, and thanks everybody for being here, and it's great to be a part of this panel. I don't want to repeat everything everybody said, but I do think it's fair to say that her like will never come again, that a person who can combine being the leader of an entire revolution of jurisprudence for women's rights with being one of the great justices of this modern time, and then becoming such an impactful cultural symbol for young women and basically for the whole country, that's a remarkable trifecta of things to accomplish in a life. And she did it remarkably. I have the same memories others have of being under the gun from Justice Ginsburg. It was early on in her justice career. I was up there arguing a case in which we were somewhat sloppy about whether there really was appellate jurisdiction in the case. And one thing she cared most about was civil procedure, appellate procedure, jurisdiction. And I had 10 or 15 minutes of being scolded by her as a kind of a school teacher, saying I clearly didn't know what I was doing. But then, the contrast, she was occasionally quite helpful. I was in Lawrence versus Texas. I had been grilled for about 15 minutes by her great friend, Justice Scalia. And she sort of interrupted and said, I just wanted to ask you a question, Mr. Smith. Just to be clear, you do want us to overrule Bowers versus Hardwick, right? And everybody sort of sat back, and I got 5 minutes to give my entire spiel about why that old case should be overruled. And it changed the entire momentum of the argument. So I've always appreciated that she did that as well.
Thank you, Paul. Marty? Marty, you're muted.
Thank you, Irv, and to my fellow panelists, it's always an honor to be among you for this event. Unlike my fellow panelists, I never appeared as an oral advocate before Justice Ginsburg. I knew her well through mutual friends and through her husband, Marty, who was a beloved member of our faculty. And Justice Ginsburg was an extraordinary friend of Georgetown University Law Center, appearing before virtually the entire first-year class and often many more students than that, and at least an annual basis for decades up until this very year. Someone counted the number of times she's appeared, and it's about 24 times in the last 20 years at Georgetown, with extraordinary candor, but also discretion and inspiration for all of our students. And it was just one of the highlights every year. She really cared about reaching young people and young lawyers. But I guess I'll end by quoting something that I noticed Friday evening or Saturday. One of her first Supreme Court clerks, David Post, uncovered this. I'm not sure where he got it, but he posted it, and I think it captures something that explains the woman and the jurist and the public servant that she became. It's sort of a distillation of everything that I think about when I think of Justice Ginsburg. And the remarkable thing about it is its date. It's dated June 1st, 1946. The young Ruth Bader was 13 years old in Brooklyn, New York. The photographs of the death camps had recently been shared publicly for the first time. I believe it was either right before or just after her mother had been diagnosed with cancer that would take her from Ruth at a very young age after she had already lost a sister. And it's an extraordinary little essay that I'd like to read. I apologize in advance if I break a little bit. I tried this with my students yesterday unsuccessfully, but because I think of her when I read it, and I think it's an extraordinary document. So this was an essay posted on June 1st, 1946 in the Bulletin of the East Midwood Jewish Center, which was the place of the shul, the synagogue, in her neighborhood in Brooklyn. So this is what the 13-year-old Ruth Bader wrote as a young girl who had grown up with some tragedy, but with the comforts and privileges of those of us who were here in the United States, those of our parents and grandparents who were here in the United States, while their relatives and so many others were in a very civilized society and nation being slaughtered in such numbers in such hideous fashion. And this is what she wrote. The war has left a bloody trail and many deep wounds not too easily healed. Many people have been left with scars that take a long time to pass away. We must never forget the horrors which our brethren were subjected to in Bergen-Belsen and other Nazi concentration camps. Then too, we must try hard to understand that for righteous people, hate and prejudice are neither good occupations nor fit companions. As Rabbi Alfred Bettelheim once said, prejudice saves us a painful trouble, the trouble of thinking. In our beloved land, families were not scattered, communities were not erased, nor our nation destroyed by the ravages of the World War. Yet dare we be at ease? We are part of a world whose unity has been almost completely shattered. No one can feel free from danger and destruction until the many torn threads of civilization are bound together again. We cannot feel safe until every nation, regardless of weapons or power, will meet together in good faith, the people worthy of mutual association. There can be a happy world, and there will be once again, when men and women create a strong bond toward one another, a bond unbreakable by a studied prejudice or a passing circumstance. Then, and only then, shall we have a world whose structure is the brotherhood and sisterhood of men and women.
Thanks, Marty, and thanks, everyone. At this point, let's begin our scheduled program. Last term was by far the most consequential in recent memory in terms of the sheer number of blockbuster cases. It also had more cases with surprise endings than any term I can remember. At first glance, this term seems like it will be a reversion to the mean, with far fewer blockbusters and far fewer unexpected results. But lurking in the background is the possibility that this could become the most tumultuous and divisive term since the Supreme Court decided Bush v. Gore 20 years ago and effectively determined who would be president of the United States. To discuss these possibilities, we will have an outstanding panel of Supreme Court experts who you've already heard from. We will be discussing the Affordable Care Act, religion and sexual orientation discrimination, aiding and abetting human rights violations, computer crime, and election law cases affecting the presidential election. Our format is as follows. One of our panelists will present a case. After the presentation, others will be invited to offer their take of that case. And then we will take questions from the press on that case. We will proceed through each case in like fashion. As an advisory to the press, I want to alert you to the fact that we will not comment on the political issues of whether a new justice should be appointed and confirmed under this president or the next, or whether the size of the court should be increased. We start now with Roman Martinez in California versus Texas. Roman.
Thanks, Irv. So I'm just going to talk a little bit about California versus Texas, which is, of course, the Affordable Care Act case or the Obamacare case, depending on how you want to characterize it. This is sort of round 3 in the series of major constitutional and statutory challenges to the act that the court has dealt with since it was enacted. Of course, you have Nfib versus Sebelius, and I'm by far, I hesitate to talk about that case with Don and Paul here, who argued the case. And in Nfib, the court upheld the constitutionality of the mandate to purchase health insurance as an exercise of Congress's tax power, but rejected the idea that it was a valid exercise of the commerce power. We had a case a few years later, King versus Burwell, that examined a very tricky and very important statutory question. And now we've sort of come full circle because in California versus Texas, the court is once again dealing with the question of the mandate, except it's in a slightly different statutory context. And so what basically happened was that a few years ago, in 2017, Congress amended the Affordable Care Act to essentially eliminate the tax component. And I got to be careful what word, I'm going to try to describe this case neutrally, but the words matter here. But it basically zeroed out the tax component of Section 5000A of the law, which is the mandate provision. And so it left everything else intact, but it essentially said that you know, if a person does not purchase health insurance, they'll have to pay a tax. But then when it sort of explained what the tax was, the law now says that the tax is zero. Congress did this essentially to provide citizens relief from the mandate as a practical matter, because with the tax at zero, it essentially gives citizens the option the option not to comply with the mandate, which remains on the books, but there's very little consequence for non-compliance because you don't have to pay a penalty, you don't have to pay a tax. Texas, 17 states, and a couple of individuals sued, and they said that that by eliminating the tax in 2017, Congress had essentially transformed the mandate provision back into a pure mandate that could not be justified under the Congress's taxing power, because again, the tax had been reduced to zero, which meant that if the mandate was valid, it had to be valid under the commerce power. But we know from what the court said in Nfib versus Sebelius that the commerce power doesn't cover this. Therefore, the mandate such as it remains in the statute is unconstitutional, the challenger said. And in addition, and here's the real crux of the case, they said that because the mandate provision is so integral to the entire statute, including the guaranteed issue and community rating provisions, essentially the provisions that require coverage of pre-existing conditions and that affect the prices that can be charged to people who want insurance, but also the connection between the mandate and all other provisions of the act, the challenger said the entire statute has to fall. California and the House of Representatives are in the case, intervened in the case to defend the mandate, to defend the law as a whole, and to say that the mandate as it currently exists, or the mandate / tax of 0 as it currently exists, are perfectly constitutional. The district court agreed with the challengers to the statute and essentially said that that the law as it currently stands is unconstitutional, and that it can't be, the mandate can't be severed from the rest of the statute, so the whole thing has to go down. The Fifth Circuit agreed on the question of whether the mandate as it currently stands is constitutional. It said that it was not, but it remanded to the district court to do a more fine-grained analysis on severability. The Supreme Court granted cert, and the court is now going to address 3 major issues. One is whether the challengers to the law have standing. The second is the constitutionality of the mandate. And then the final one is the severability question. I won't say a lot about the standing issue now, although it is an interesting and important issue. It does seem to me that if the court on the merits thinks that there is a mandate here that is significant, that will probably lead it to think that challengers do have standing to challenge the law. But just jumping to the constitutionality of the mandate, which is really going to be the first merits question, the basic argument is about how to construe the statute as it stands. One interpretation which the challengers put forth is that you have a mandate now. It's not a tax anymore because the tax has been zeroed out. The saving construction that Chief Justice Roberts in the Nfib case put on the statute essentially rested on it being a tax. A big feature of that analysis was the fact that the mandate provision taken as a whole raised revenue from the government because of the tax penalty. You can't raise revenue if the tax is 0. Therefore, it's no longer a valid exercise of the tax power. The defenders offer a couple of arguments in response. One thing they say is that it's still a tax, or I think as they say, it's a suspended tax, which is an interesting formulation, which I hadn't really heard of before, as an exercise of tax power. They also say that, as a practical matter, there's not really a mandate because there's no hammer attached to it. There's no coercive penalty or tax that attaches to not complying with the mandate. Therefore, it's essentially precatory, and it's not unconstitutional, and therefore there's no constitutional problem here. If the court agrees with the challengers that there is a mandate and that it's not justified as a tax anymore, then the court gets to the severability issue. And the challengers to the law say that the entire statute has to fall. They rely heavily on factual findings that Congress made in the original Affordable Care Act statute that linked the mandate to certain other provisions, including most directly to the guaranteed issue and community rating provisions. And they point to the fact that when the Obama administration defended the mandate the first time around in NFIB, it acknowledged that the mandate was linked at least to those provisions. And the dissenters in the NFIB case had also said that the entire statute should fall if the statute was unconstitutional. The challengers revisit those arguments. The defenders, on the other hand, say this is crazy, that severability turns on congressional intent, that it would be an absurd outcome to essentially strike down the entire Affordable Care Act statute, which is 2,000 pages long, simply because Congress in 2017 decided to essentially just eliminate the tax component of the mandate. It's obvious that when Congress has been debating the Affordable Care Act, including in 2017, it considered whether to repeal the whole thing. It decided not to. Decided what it wanted to do was essentially make the mandate a toothless mandate. Even if it's still a mandate, it does not have coercive effect. It didn't change everything else in the statute. And so if severability turns on issues of congressional intent, the defenders of the law say, then that intent is clear that Congress wanted to have a toothless mandate, but did not want the rest of the statute to fall. So those are basically the legal arguments. I'll just offer a couple quick sort of observations on the case. It strikes me that the case is, it feels sort of artificial, frankly, on the constitutional issue. There's some great lawyering on both sides and very clever arguments. But at the end of the day, I found the lawyering, although very good, they're sort of arguing about this almost fake question. You have a situation in which the Chief Justice's construction of the statute in Nfib was kind of just barely plausible, as his own opinion seems to concede. If you read the text of the statute, it reads like a mandate. It doesn't really read as a tax. The chief just barely got around to endorsing the tax interpretation of the statute to save its constitutionality. I think now the defenders of the statute are asking the chief essentially to go a step further and say, okay, well, you saved it as a tax. Now we've zeroed out the tax consequences. So it's not really a tax in the same way, but you should apply the same logic and say that essentially it's still a tax or it's not really a mandate, even under the new statute. I think it's a long shot. Forgetting, I think the Justices Alito and Justice Thomas, who didn't like that argument the first time around, it seems like a real stretch to get Justices Kavanaugh and Gorsuch on that theory, given that it seems unlikely that they would have been with the chief the first time around, but who knows? The chief, I think, has to make a decision about whether he wants to kind of dig in deeper to the statutory construction that he agreed with the first time. But even the interesting thing is about the case is that the ultimate question about whether the mandate is constitutional or not doesn't really have a lot of practical significance in and of itself. What really matters is the severability question, because that is what is really going to have an impact on people if the entire Obamacare Affordable Care Act statute is struck down. And on that side of the House, it seems like the challengers to the statute have a very uphill battle here. As the defenders of the statute say, it seems fairly clear from the history, at least, that Congress wanted to have a world in which there was a toothless mandate coupled with the remaining provisions of the Affordable Care Act remaining in place. And traditionally, severability has turned on indications of congressional intent. You also have a situation in which both the Chief Justice and Justice Kavanaugh have often, and recently, last term, endorsed the severability doctrine and a strong presumption of severability. We can talk about details of that, but I think the line that jumps out to me is from a decision that Justice Kavanaugh wrote, unfortunately ruling the wrong way against my client in a case last term that involved severability. But he said constitutional litigation is not a game of gotcha against Congress, where litigants can ride a discrete constitutional flaw in a statute to take down the whole otherwise constitutional statute. And I think what the defenders of the Affordable Care Act would say is that language fits squarely and squarely describes the litigation that's going on here, and that really the challenge to the mandate, which doesn't really mean much, is just being used as an excuse to take down the rest of the statute. It seems to me that the challengers may have an uphill argument on that point. I guess the final thing I'll say before opening it up to broader discussion is just that this case has obviously provoked a lot of political commentary over the last few years. It played a prominent role in Justice Kavanaugh's confirmation hearings. It's playing a prominent role in the election. I think in the popular discussion of the case or understanding of the case, it seems very politically charged and very contentious. And that's understandable because of the fact that it does implicate this fundamental legislation that's been controversial since it was enacted. That said, this strikes me as the kind of case where it's possible that people will ultimately be surprised a little bit by the way it's resolved. I think this is a case that is a candidate for resolution on the severability grounds that is not going to turn on the standard partisan alignments. And partly for that reason, I think it's a case that even if the court remains at 8 justices, and we don't know exactly how that's going to play out, it's the case that might be able to get decided anyway. And so this might be a case that'll surprise some people who think it's just going to attract the normal political alignments. But of course, we'll just have to see. I'll leave it at that, Irv. Thank you.
Thanks so much, Ramon. At this point, anybody else who wants to comment, please do so and just grab the floor. I'm not going to call on you.
So I agree that the severability issue ought to not be difficult, and it may well be that the court can agree around that and make this an easy case. On the other hand, if you try to identify the cases on the docket that might turn on the addition of a new justice, this may very well be that case. It's at least imaginable that the Chief Justice would have not taken this thing down. Now that he's no longer the sort of controlling fifth vote, if a new justice comes along, it's conceivable that he may find himself in disagreement with his conservative colleagues.
Hey, Irv, this is the other Paul. I would just say that, I do think that on the merits, the addition of a new justice could make a difference potentially. But I think I'm probably in agreement with Ramon that on the severability issue, I'm not sure that that the addition of a justice will make much of a difference. The only other thing I wanted to say is, maybe two very quick, closely related things. I do think it's worth underscoring how different the severability question is this time around from back in the day in NFIB, because it's one thing to make the severability argument in the context of the statute the first time it's passed and there haven't been subsequent efforts to repeal it that have failed. It's quite a different thing to make the argument in the context that we now have, especially given that the mandate has been amended to have zero kind of teeth or zero revenue raising effect. So it's just hard for me to say that even though I said it to the court back in the day that the mandate was central, and I think that was a pretty good argument back in the day. It's a little harder to say that the mandate is central when it doesn't have any teeth. And, so I think it's just a very different argument this time around. The second thing I'll say is there is a little air of surreality around the severability issue. And, there are a lot of different ways to come at this, but it's not like the federal government, for example, even though they're arguing in favor of taking the whole statute out, that they're really acting consistent with that view. And like one way to, sort of encapsulate this that obviously strikes home for me is I argued a case last year about the risk corridor payments under the Affordable Care Act. And, that was a case where, my clients prevailed, the federal government lost. The federal government, has since then, in the months since that decision, written a bunch of very large checks to health insurers under the statute. And it just seems like if the whole statute is actually void and, collapses, you'd think that might have come up in the context of that case. I mean, I'm not, you could quibble about whether, because these obligations were incurred back in the day, the non-severability of the statute is dispositive, but it sure seems like it would be relevant. And the fact that we got all the way through the main community health case and, the federal government never stood up and said, oh, by the way, the whole statute's unconstitutional and must fall. There are federal agencies right now that are exercising authority under provisions of the Affordable Care Act that are unrelated to the mandate. It just all seems a little surreal. Maybe it's just another way of saying that I think the challengers have a very uphill battle when it comes to making the severability arguments.
So if I might jump in, I agree with Ramon and Paul. I don't know who's the first Paul and who's the second Paul, but Paul the latter, Paul the former. But that there is an air of what Paul called an air of surrealability or surrealness about the severability argument. It seems preposterous, obviously not what the 2017 Congress intended. They intended the opposite. But for all that, and there are somewhere between 3 and 4 dozen amicus briefs arguing that it is severable, or demonstrating what the catastrophic outcomes would be if the court held otherwise. I filed what I think is the only amicus brief arguing that the first question, the question of whether the 2017 Congress actually enacted a mandate, a requirement for people to purchase ACA-compliant health insurance, that question seems to me, but apparently only to me and a couple of other people, even easier and more surreal than the severability argument. I think the notion that the 2017 Congress and Donald Trump imposed a mandate to purchase insurance is contrary to the plain text of what they did in light of the Chief Justice's construction of the statute to give a choice between A and B. And they didn't amend A or B. You can maintain health insurance or pay the personal responsibility payment, which is now zero. They didn't amend that. They knew that that was the construction of the statute. The President of the United States last week in his town hall with George Stephanopoulos said for the 4,000th time, I got rid of the most unpopular thing in Obamacare and a very unfair thing, the individual mandate. He didn't just say it then, he said it when the bill was introduced. He crowed about it in the State of the Union address the day that he signed the bill, saying that people don't, now we're overturning the mandate. And every one of the members of the Republican majorities in both houses agreed and described it that way, right? Majority Leader McConnell, the Senate accomplished something really remarkable. We repealed the individual mandate tax so low and middle income families are not forced to purchase something they don't want or can't afford. My point is not simply that their intent as reflected in these statements governs. It's that that intent and those statements reflect the only reasonable reading of what the 2017 Congress did. It turns the world on its head and reality and what everyone knows on its head to suggest that what they did was to create a mandate to purchase insurance, particularly given that the Supreme Court had just decided that Congress doesn't have the constitutional power to do that, a view that 43 members of the Republican majority in the Senate, including the majority leader, agreed with in a brief to the Supreme Court. The idea that this Congress, brazenly enacted a law knowing that the Supreme Court had just called it unconstitutional, kind of like the 1862 Congress passing a law to prohibit slavery in the territories in order to rebuke the Dred Scott decision, is surreal, doesn't even begin to describe it, Paul, is what I think. And so but I agree with my fellow panelists, this should be a 2-paragraph opinion, unanimous. It's in my brief, I called it virtually the easiest statutory question the court's ever confronted. And yet I agree with my panelists that if the views of the lower court judges are any indication, and what I've seen from other commentators, there's a real chance that some justices, perhaps a majority, will hold that the 2017 Congress imposed a mandate despite the fact that they were all trying to do exactly the opposite, and that's how everyone understood it. If that's what happens, I have to say, I don't know whether to be it'll be the most cynical thing the Supreme Court has said in many a decade, but it will be the most incomprehensible, and I think it will make a mockery of what we try to teach our students about the law, right? And I say that, by the way, as someone who thought that Sebelius would be a 5-4 decision, and who thought the court might very well rule the other way in King versus Burwell. I thought those were close cases. This one should not be on both questions, the first and the second. But on the first, I'm afraid that I'm not sure that is the view of all of the justices on the court. I hope the Pauls and Roman are right about at least the severability part of it.
Well, I want to hear what Don has to say, since he's going to be the one. Maybe he doesn't want to. Maybe he doesn't.
I'm just taking notes. I
don't know, and maybe you can talk about whatever you want. But one question that's on my mind is how much, the current circumstances come into play here. I mean, we're in the middle of a pandemic. We have a statute that, it has been in place for a while, seems to have been working for years. And we have a president who often says that he wants people to have healthcare. I don't know how much to put on his statements because they seem to flip-flop quite a bit. But I want to hear from Don to the extent he's willing to give some thoughts.
No, as I said, I'm mainly just taking notes here. Paul Smith made the point that the Justice Ginsburg's passing and perhaps the filling of the seat might have an effect. And who knows, maybe that's true. nothing's ever been easy about the Affordable Care Act, in my experience at least. And so why should this one be easy? On the other hand, our case is just as strong today as it was a week ago. And so I'm hopeful that at the end of the day, the arguments that we're putting forward will be as persuasive as Roman is predicting they will be.
Okay, so I think it's time for questions from the press.
Can you hear me?
We can.
Okay. Hi, thanks for doing this session as always. I just wanted to ask a quick question about whether if a Biden administration and a Democratic Congress took office and were to set the penalty at $1, does the case go away?
That's a great question. I don't know, I don't know how quickly they could act, although presumably they could act quickly. It does seem that it would just make this surreal case even more surreal if that's the next step in the saga. It does seem that under the if they did that, then you'd be sort of a lot closer to the world in which the chief confronted the how to characterize the mandate provision the first time around. And so it would arguably still be a tax, although, at that point, maybe he would say, hey, this is just too ridiculous to maintain the illusion that what we're doing here is right, and this is just total pretext. But it certainly, I think, would make the case harder. I don't know if others, I think, Marty, your very well done amicus brief, I think, has the hypothetical of the 1 cent tax, right?
Right. We say if the 2017 Congress had set the tax at 1 cent, there'd be no case. Mark, you're right. That's a good question. Everyone would agree. And so for that penny, the entire Affordable Care Act comes down. It's an absurd idea. And it's not because what one's left with is an exercise of the taxing power necessarily. The parties, Don and California, have made the argument that it can be sustained still under the taxing power. But you don't need that. It is perfectly constitutional for Congress to give people a choice of 2 things if they could require one of them. And here the choice is maintain health insurance or write a check for 0 or do nothing. And those are things Congress can do outside the taxing power. Congress can obviously repeal a tax. It has the power to do that. Well, that's effectively what it's done here, at least temporarily, repeal a tax. I think, Mark, your hypo shows the absurdity of what I call the first argument.
Yeah, except let me just jump in on that, Marty, because I think your framing of it is very clever. It's really, you're talking about whether they imposed a mandate in 2017. That's not really the question. The question is the statute as it stands, and the statute as it stands was enacted in 2010, and it's got pretty clear language that is most naturally read, as even the Chief Justice said, to create a mandate. The only reason he read it the other way was because he thought it was a tax, in large part because it raised revenue. And so I don't think it's easy or obvious that once you get rid of the revenue-raising feature of the tax, that it doesn't just collapse back into being a mandate the way it appears on the page. And I think if the current version of the statute had been the one on the books in 2010, I think Don and the Obama administration would have had a much harder time prevailing.
That's true, but the 2017 Congress acted against the backdrop of the construction the court had given it and took that as a given. That's what they worked against. The only reason they didn't repeal it outright was an internal rule, the Byrd rule, that didn't allow them to do so in reconciliation. And so we're not wiping the slate clean. This court had construed these words as providing a choice to individuals, and Congress did not amend those words. So it's still a choice.
No, but it interpreted them that way in part because they had a revenue raising aspect to them that made it actually look like a real tax. Now it's not a real tax anymore; it's a fake tax or a tax for 0.
Well, I'm not.
Well, we can disagree on that.
The brief speaks for itself. Okay, so
but it's not easy. Anyway, but I enjoyed your brief, Marty. Well done.
Thank you, Roman. It is meant to be enjoyed.
Anybody else on just a question that Mark had? Then do we have any other questions?
Mark Sherman, AP.
No.
I thought we just had Mark.
Just had Mark.
Oh, we just did. Wait, oh, Susan, I'm sorry, forgive me. Susanna Luthi, Politico. Apologies.
Thank you. Can you hear me?
Yep.
So I was rereading the Chief Justice's past decisions, and I believe it was the Sebelius decision. He basically says the mandate, the coverage guarantees, and the subsidies are all tied together. So do you see kind of a specific threat to Title I, including, I mean, I've heard speculation that the coverage protections might be the most at risk in this case, but what does that do to the subsidies, and do you see all of basically the exchanges kind of imploding as a potential outcome?
I'll leave it to others who know more about the intricacies, but I think the baseline answer is I think that really is the kind of severability question, which is whether that we've been talking about essentially, you know, if the challengers win on their severability argument, that would mean that everything else goes down and is invalidated. And so I think that would, as I understand it, would apply to the entire 2,000-page law, which is part of why it feels like a bit of an uphill argument.
Yeah, and if I can just follow up on that, you know, I think this is a good way to illustrate the difference between the severability argument this time around and last time around. Because, you know, last time around when you were looking at this organic statute that fit together and was all passed at the same time, and it had a mandate that was a real mandate enforced by penalties, and you had a whole bunch of people saying you really need a mandate and a real mandate enforced by penalties because we've seen in other states like Massachusetts or whichever one it was, you know, it's a while ago, so I may have forgotten which state, but, you know, we've seen states that have passed guaranteed issue and the like without a mandate, and it hasn't worked. There was a, you know, premium spiral or, you know, whatever it was. That was a pretty good argument, you know, got 4 justices vote back in the day. It's just a very different argument to now say when the Supreme Court has just reinforced that severability analysis is all about congressional intent. It's a very different argument to say that Congress would never want the statute to have guaranteed issue or its other features without an individual mandate, when Congress itself has turned the individual mandate into kind of a non-mandate by attaching a zero tax. So it just, you know, so you're right in the sense that like the severability argument sort of, you know, when I was making this argument back in the day in Sebelius, it reminded me of that, you know, old thing about, the hand bones connected to the wrist bones connected to the arm bone. I mean, you know, you have this whole process where the statute is kind of, you know, the way you make the argument is to say, look, guaranteed issue doesn't work without the individual mandate. And then another feature of the statute doesn't work without guaranteed issue. And pretty much if they couldn't have those core features of the statute, Congress really wouldn't have wanted the whole thing. Like I said, I think that was a pretty good argument back in the day. But to make that argument in the context where Congress, after it was done with its 2017 work, left the whole statute in place with a zero tax mandate, boy, that's just a very different argument. And it seems like a tougher argument. And it seems like a tougher argument even as to the first step in the chain of guaranteed issue and the rest of the stuff in that title.
Anyone else want to comment on this question about, I think it's whether the subsidies are at risk? Okay, next press question.
No pending questions.
Okay, so we then move, next up is Paul Clement, and he has Fulton versus City of Philadelphia. Paul.
Thank you, Irv. I'm going to talk about this case. I think it's a potentially important case, but I think I can cover it relatively quickly. So this is a case with 2 potentially really important issues in the religious liberty area, but I also think a lot of potential for the court to decide the case without really definitively deciding either of those big ticket issues. So the facts of this case that I think are relevant is that the City of Philadelphia has long had a foster care placement system where they partner with organizations that some of which are religious, some of which are non-religious. But the way the program works, in essence, at least as I understand it, is that the organizations essentially are responsible for finding the foster families that can provide a foster home for the children who are in need of foster care. So the city has this, it's the city of Philadelphia. It faces a lot of challenges. And so there are a number of children in the city that are in need of foster care placement. And so what these organizations do is they provide they go through whatever screening, they go through and they do home visits, and they come up with essentially, lists of available foster care families. And there are dozens of groups that participate in this. And, some of them are religious, some of them are non-religious. Well, one of the religious groups that has participated in the program for literally decades is the local Catholic Social Services Organization that's part of the Archdiocese of Philadelphia. It probably wouldn't surprise, anybody who, kind of understands Catholic doctrine that the Archdiocese Catholic Social Services has a doctrinal issue with certifying parents to act as foster families if they are in a same-sex marriage relationship. So the position that the Archdiocese has taken is that they will essentially certify a family if they are a traditional kind of male-female married couple. They will certify families if they are single-parent households. I believe their position is that they will certify single-parent households even if one of those single parents is gay or lesbian. But when it comes to a married couple that sort of presents themselves as a same-sex married couple, that's not something that, consistent with Catholic doctrine, the Archdiocese Catholic Social Service can essentially sanction or certify. That doesn't necessarily mean that those couples are out of luck if they want to participate in the foster care program in the city of Philadelphia, because there are these, some 24 other organizations that they can go and get certified through those other organizations, and they participate through these other organizations rather than the Catholic Social Services. Probably because of, that phenomenon, that there are alternative ways for a same-sex couple to get certified and participate in the program. This was not a case where this is not a case that kind of like the famous case of the Colorado baker. This was not a case where this case started with a family complaining that they couldn't participate in the foster care program because the Catholic Social Services wouldn't certify them. This is a case where it started, and I suppose the press will feel good about this. I think this case actually started with like a Philadelphia Inquirer story that said, hey, the Catholic Social Services has this position and they won't certify same-sex couples. And that created some pressure on the city of Philadelphia government to sort of do something about that. And they eventually took action against Catholic Social Services and basically said, look, we have city anti-discrimination policies that say that if you're a city contractor, you can't discriminate on the basis of sexual orientation. You are discriminating on the basis of sexual orientation. Now that we know that, we're going to, essentially force you to a choice of either agreeing to our non-discrimination language or discontinuing your participation in our program. So that's the case that I think is, just the essence of the case that gets litigated. And the two big issues that are potentially up for the court's decision, the one that's obvious just from the facts of the case, is what happens when you have a conflict between a non-discrimination principle under state or could be federal law, and a religious liberty claim. So nobody here doubts, or is challenging the sincerity of the religious beliefs of the archdiocese. So, they say we have, essentially a free exercise right to our beliefs. But, the city's also saying, well, okay, but, if you want to participate in our program, you have to participate in our program subject to our conditions that are neutral and generally applicable laws that apply to all applicants. And so you can't just sort of say you want to participate, but not subject to our conditions. And, that conflict between a, state non-discrimination law and a free exercise claim was, at the core of, cases that the court had previously involving the Colorado Baker, and they, essentially found a way to work around them and not give a definitive resolution of that issue. But that issue is once again sort of front and center. And that's obviously a huge issue. You only have to read Justice Gorsuch's opinion for the court in the Bostock case to know that that issue is kind of lurking behind the scenes and is an issue that the court will have to resolve one of these days, one way or the other. The second big issue in the case is whether the court should overrule a decision written for the court by Justice Scalia called Smith. The Smith decision says that if you have a state law that is general and neutral, law of general applicability that's neutral in its application, that kind of state law essentially doesn't trigger heightened scrutiny under the free exercise clause. So, if I'm somebody who says that as part of my religion, I want to use the ceremonial use of peyote, and that's super important to my religion, and there's this state law that says that peyote is a Schedule I substance and it's unlawful to use or possess. There's a conflict between my religious exercise and a state law that's neutral and generally applicable to everyone. The court in Smith said those kind of laws, even though they may substantially burden your religious exercise, are not subject to strict scrutiny and are generally going to be constitutional. And the Third Circuit, in upholding the city's practice, at least at the PI stage, relied heavily on Smith. One of the questions presented in the petition was whether the court should overrule the Smith decision. That's something that 3 or 4 justices had indicated an interest in a concurrence in the dissent of cert in a case about 18 months ago. So the issue is really teed up, and there's a potential that the court could overrule the Smith decision, which would be a very big deal. And if the court were to overrule Smith, I think that this case would really be almost the capstone on the 3 religious liberty cases from last term, and would continue to kind of really cement the current court's kind of vindication of the free exercise clause and really elevating that, over concerns about establishment of religion and the rest. Obviously, if the court confronts this really, central issue about what to do with the conflict between state anti-discrimination law and federal free exercise claims, that would be a huge deal. But I have to say, my own reading of this case is that there are a lot of off-ramps for the court if they don't want to decide either of those 2 issues. There are, for Smith to apply, the law has to be generally applicable and neutral in its application. Exactly what that means and exactly what makes a law not generally applicable and what makes it neutral is a kind of confusing morass. But this is not a situation where Philadelphia can point to this super obvious, city Title VII anti-discrimination provision where they've applied it neutrally and generally forever. This is the history of this is just more complicated, and these are largely contract terms, and the government can insert it in certain contracts, but not in others. So there's plenty of scope for the court to take an off-ramp and say, look, the Third Circuit got it wrong in thinking that Smith was fully applicable here. There is also, as in the case of the Colorado Baker, a lot of, sort of record evidence. I think that if I were the city's lawyer, there are some statements that were made when this issue was first raised that I would really wish I could take an eraser to. Kind of in the vein of some of the comments of the Colorado commissioners. So I think there are a lot of off-ramps here. So, I think this is a really important case. It could be that, if there's, a new justice that sort of agrees with, some of the existing justices, say that, the dissenters in the religious liberty cases in the COVID context, you sort of get 5 justices that really want to move the needle very quickly in this area. You could have the court, deciding one of these 2 really important kind of issues that would make this a definite blockbuster. But I still look at this as a case with a surprising number of off-ramps.
Others who would like to comment? Just take the floor.
Okay, I'll jump in again if you don't mind, Irv. I largely agree with Paul's description and his predictions that this is, there's again about 4 dozen or more amicus briefs about whether Smith should be overruled on both sides. And I think this is, not the right case to do that, because either way, Smith is not really relevant. On the one hand, Paul's right that the SG's brief is not at all, is entirely about the argument that either animus or the lack of general applicability is what dooms this rule. And I suspect that if the court rules against Philadelphia, that will be the most likely ground. It's a hard argument to actually make because of the strange posture of the case. Catholic Social Services is not seeking damages or any retrospective relief. It's seeking only to be eligible for a contract on its desired terms going forward. And now there is a provision in the standard contract that just very clearly and categorically bars discrimination on several different grounds, including race, ethnicity, sex, sexual orientation, et cetera, that is categorical. Philadelphia has now said, we're clarifying for the future, none of these contractors can discriminate on these grounds, full stop, period, no exceptions. And so given that that's the case, it's sort of hard to bring in these past statements as in Masterpiece Cake Shop, or the argument that it's not generally applicable. But those turn, as Paul suggested, largely on facts, that are unique to the case, and a fight about what the facts show and about what Philadelphia is likely to do going forward. On the other hand, if the Philadelphia says that even if Smith were overruled, the regime that was in place between 1963 and 1990, the one that the folks who are trying to overrule Smith would try to return to, they'd still win under that regime, right? So even if Smith were overruled, Philadelphia should win because all that's being done here is preventing Catholic Social Services from engaging in a contracting function, not only a contracting function, but one in which it is acting in lieu of the state and performing a state function, right? So it's actually the Pennsylvania Department of Health and of Human Services that has delegated its statutory responsibility to, as Paul points out, certify whether a family does or does not meet statutory criteria to be able to foster a child, which is those are non-religious secular standards. They're standard, and that decision is appealable to a division of the Pennsylvania Department of Health of Human Services. So this is as though you have an employee who doesn't want to serve same-sex, doesn't want to perform functions with respect to same-sex couples. Well, that's fine. You don't have to on your own dime in your own time, but your job is to cover everyone the same. And I think that's a pretty strong argument that when someone is getting millions of dollars as part of a contract to perform a governmental function, the nature of which is to see if certain statutory criteria allow someone else to have a certain legal status, that they have to do so on the terms that the government itself would be using, which are non-discriminatory terms. And so I don't think the question of Smith being overruled affects the case either way, and I would be shocked if the court reaches that question here. As I've suggested, I think it's actually hard to write the opinion on behalf of Catholic Social Services, just in terms of the doctrine. But for these justices, it's never hard to write an opinion coming out the way they want. And I sort of do suspect that there will be many justices who are inclined to find a way to rule for Catholic Social Services, even though I think the city ought to win on the facts of the case. Because I think many of the justices think that Philadelphia, even if the Constitution didn't compel it, the city ought to have granted a religious exemption in these circumstances, right? It ought to be conciliatory now that same-sex marriage has been recognized as constitutionally protected. You see this theme in Kennedy's opinion in Obergefell, in Gorsuch's opinion in Bostick, right? That for the next several years, the justices are hoping that jurisdictions are somewhat deferential to religious objectors, to find win-win situations in which the same-sex families can be served, but at the same, and not suffer discrimination and not suffer sort of odious discrimination, especially from potential state actors, but at the same time allow some sort of out, right? So for instance, in the pharmacy, for instance, allowing an objecting pharmacist to be the one who not to distribute a controversial drug, as long as there's another pharmacist available to do the same. I think a lot of the justices think that Philadelphia ought to have found a way to accommodate Catholic Social Services here, and will be inclined at least to try to find a way to make that happen, even though I think the law is actually points in the other direction.
Anyone else?
Let me pipe in just quickly. I agree with Marty that the status of the Social Service Agency as a contractor ought to be significant in terms of undermining their constitutional arguments. On the other hand, it seems very clear that there's going to be lots of justices looking for a place to start on an enterprise of creating more space for religious liberty claims faced with anti-discrimination laws of protecting LGBTQ people. We've seen this now building up, and the urge to get that enterprise going, which is all the stronger, I think, in the wake of Bostock, which had such a huge expansion of anti-discrimination protections across the country for gay, lesbian, transgender people from employment discrimination in the private sector. That's why Gorsuch went out of his way to promise that there's going to be lots of legal developments in the area of religious liberty protections for employers. And I would be surprised if, given all the murky facts here and the fact that the rule wasn't real clear until after the case got going and everything, that if 5 justices couldn't find a way to do a kind of narrow gauge ruling for the Social Services Agency, not dissimilar to the Masterpiece Cake Shop case.
Irv, you're on mute, Irv.
Anyone else on this one?
I will just add, if there's waiting for questions, that this is one of those cases in which the briefs are ships passing in the night. It's all about how you characterize the case. So Catholic Social Services says that being denied this contract excludes them from the historical ministry of caring for foster children. And it really doesn't, right? Philadelphia says, no, it doesn't. You can do all the things that you've done for hundreds of years to care for children, even to help foster families, to promote them, to help them do this. You just can't be the one who's on our dime certifying them as satisfying statutory standards. So it's not affecting your religious exercise outside the context of the contract. Catholic Social Services says the city of Philadelphia, like most jurisdictions, has sort of monopolized the field over the last 100 years, leaving us very little space to do what we might have done in the 19th century, creating orphanages and the like. And that occurs on the general applicability question too, right? The description of the facts and the implications of the contract being denied here, or the conditions being placed on the contract, there's really very little common ground in the briefs, and the court can probably we'll probably be inclined to lean one way or the other on that.
Could I just ask a general question before we go to the press? As Paul said, it would be a huge deal to overrule Smith, because it would basically say that anybody has a religious objection to any law of general applicability would presumptively have a right to an exception from the law. Maybe that's oversimplifying, but back at the time of Smith, almost the entire right side of the court joined Justice Scalia's opinion, setting up this rule that laws of general applicability that are neutral are, okay. No exceptions required. Almost the entire left side of the court dissented and said there ought to be a presumption that religious objectors get an exception. Now we see the exact reversal of that occurring. The right side of the court is the part of the court that has been talking about overruling Justice Scalia's opinion. The left side of the court has not said anything about that. What's happened? Can anybody explain to me what has happened to cause this enormous shift on the right and left side of the court regarding whether religious objectors ought to have a presumptive right to an exception from generally applicable law?
Well, there's clearly been a change in the perception of who is the victim of generally applicable laws and needs to be protected in their religious liberties since 1990. The perception now, given the rise of same-sex marriage and other forms of protection for gay and lesbian people, transgender people, and then some other developments, is that it's conservative religious people, Christians and Jews, but mostly Christians, who are the victims of a legal culture which is imposing its contrary views on them and making them feel that they are being labeled as bigots and as discriminators. And you just have to read the dissents in Obergefell to see this perception coming to full fruition. And so I think that then leads to this reversal of roles of who's in favor of exemption and who's not.
Anyone else?
Yeah, Irv, I think there's two other things. I mean, I don't disagree with what Paul said, but I think there are two other things that, are at least ingredients in this. One is the Establishment Clause jurisprudence looks very different today than when Smith was decided. And, in Smith, you still had a pretty robust sort of Establishment Clause that, invalidated a bunch of state laws. There was a felt need by, I think, the whole court to sort of, figure out, where the play in the joints, existed between the Free Exercise Clause and the Establishment Clause. And so, now that I think that, the right side of the court has basically prevailed in kind of trimming back the Establishment Clause, I think, the dynamic that led to Smith is just a little bit different, in light of the changes in the Establishment Clause jurisprudence. So I think that's at least part of what's going on here. I don't think it's a complete explanation. The other thing that has happened, of course, is, Congress responded first with RFRA, then with RLUIPA, and you've had a lot of courts applying the heightened scrutiny standard to laws of general applicability in a variety of contexts where those two statutes are applicable. And and I think, the Beckett Fund makes this point on behalf of the Catholic Social Services in their reply brief, but, the sky hasn't fallen. A big part of what I think motivated Justice Scalia and Smith was that rule was important to come up with an administrable rule that would keep the courts out of a thicket that would be hard for them to sort of administer. And, I think there's at least an argument that the experience with RFRA and RLUIPA has proven that you can't apply this kind of, probably what is best described as intermediate scrutiny to these religious liberty claims. And, courts can do it. And at the same time, as this case illustrates, you know, it's proven a little harder than maybe Justice Scalia anticipated to administer the Smith's test, because, you know, the lower courts have come up with this jurisprudence about what makes a law, you know, not wholly general and what makes a law not wholly neutral. And, you know, that's a little more complicated than I think, you know, Justice Scalia had in mind. And, you know, frankly, probably a little more convoluted than if Justice Scalia were the one who were applying the Smith test, you know, all along. So I think all of those factors, you know, are at least partially explaining what's going on here.
And just Don, sorry.
One more thought too, you know, one other thing I think is going on, at least helping to explain what's happening on the left, is that a lot of the religious liberty claims, most of the ones that have arisen so far under RFRA, they involve a situation in which there's no happy ending. Somebody's got to lose. Either the the entity or the person with religious beliefs has got to do something that violates their faith, or I think in these cases, a third party, often employees in the case of an employer, is going to suffer an adverse consequence as a result of the assertion of the faith-based objection. And I think that has had an effect on the justices on the left in changing, I think, the way they do the calculus in terms of the harms and the benefits of recognizing a religious liberty claim. And, Hobby Lobby was the obvious example of that, and those various cases. But I do think that that's got some explanatory power for justices on the left.
And I would just put together Paul and Don's comments to say that the pre-Smith rule, called the Sherbert-Yoder rule, was on its face a form of strict or heightened scrutiny, but it was famously strict in substance, feeble in fact, right? That the court, notwithstanding that strict scrutiny, virtually always ruled for the government, including in non-discrimination cases, 8-1 in the Bob Jones case. And remember, even in the peyote case, the most passionate defender of the pre-Smith regime, Justice O'Connor, would have ruled for the state and allowed them to prohibit the peyote use. And so that's why it was a regime in which there was nominally strict scrutiny, which had some effect on the ground with administrators and legislators to make them be conscious about, possibly giving some way to religious objectors, but in which the courts would never really insist upon exemptions. But under RFRA and RLUIPA, this court has read those statutes wrongly, in my view, to impose a regime that far from reinstating the legal test that preceded Smith is far more robust. And Justice Alito's concurring opinion in the Little Sisters case is the most extreme example of that. And so if that's the case, if this is really going to be a regime in which exemptions almost have to be granted, even in this context, if they were to overrule Smith in the context of a government contract to perform government functions such as this, that would go so far beyond the pre-Smith law that it's something, as Don points out, that the left would be very concerned about. But Paul's also right that the court now doesn't, they've been applying RFRA and RLUIPA, maybe wrongly, but they've been doing it, giving lie in their view to Justice Scalia's concern that this test was unadministrable by courts. They've been administering it. So they're, how can you say it's unadministrable?
All right, so questions from the press?
There are no pending questions.
Okay, so with that, let's move on to our next case. And who's up? Nicole?
Hi, everyone. So I'm going to talk about a business case, two cases actually consolidated. This is Nestle versus Doe and Cargill versus Doe. Here's why you should care about them. Any company, any U.S. company that has any operations in a foreign country potentially could be subject to the rules that the Supreme Court sets out in these cases. So these cases address the Alien Tort Statute. For those who've been at prior Supreme Court briefings, you've probably heard about the ATS because there have been quite a few cases over the last, 20 years or so. So this is a statute, just as a refresher, that was enacted in 1789 and essentially lay dormant until approximately the 1980s. It gives federal district courts jurisdiction over any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the U.S. So what does that mean? It opens the door that federal courts can hear claims by aliens, meaning people who aren't citizens of the US, for torts that are committed in violation of the law of nations or US treaties. What does that mean? You know what a tort is. I think the real dispute has been over the last couple of decades, what causes of action potentially can you hear that are violations of the law of nations or treaties of the US? You might think of kind of paradigmatic examples from the time that the statute was put in place, like cases involving ambassadors or piracy on the high seas. But most of the cases that have come to the courts since approximately the 1980s have involved US corporations that have international dealings and have many activities in foreign countries where something has happened in a foreign country and the company's been sued in the US. I just said US corporations, but I should amend that to say that some of these cases have involved suing foreign corporations in the US as well. I'm trying to be accurate here because these cases were primarily argued by Paul and Don, who I'm sure will have many things to say about them. So I'll give a brief overview of kind of where things stand. So as in my view, this kind of started in approximately 2004 with a case called Sosa, where Justice Souter wrote an opinion for the court, 6-3, addressing what this alien tort statute is all about. And he said for the court, the ATS doesn't create a cause of action. It just opens the courts to hear claims. These are claims from the common law that are violations of clear international law norms. And he did give the example, I think, of ambassadors and piracy on the high seas, but left a lot for the courts to figure out in terms of what would be these types of claims that could be heard in US courts. So that was 2004. Things were quiet, at least in the Supreme Court, for a little while. And then that took us to Kiobel. Just by the way, Sosa, that was Paul's case. We get to Kiobel, that's Don's case. In fact, I think it was 2 cases, but he only handled the re-argument. That's in 2013. And so the Supreme Court was trying to put some rules on who could be sued under the Alien Tort Statute, what kind of claims could be brought against them. This case involved foreign defendant, foreign conduct, and it all happened in a foreign place. And in that case, the Supreme Court, actually in a 9-0 decision by the Chief, although there were a lot of different opinions, said this is a US statute. We're going to have a presumption against extraterritorial application. So we're going to presume that the statute doesn't open the courts to claims that are based on things that happen abroad. But the Chief, in the last paragraph of his opinion, left open in the final paragraph that there could be some claims of things that happen abroad where the claims touch and concern the US. Those were the words, touch and concern. Not exactly sure what that means. Justice Breyer, in a concurring opinion, joined by the liberal justices, gave some examples of what kinds of claims might be cognizable under the Alien Tort Statute. But certainly Kiobel set out this rule that as a general matter, you're not supposed to be bringing lawsuits for conduct that occurs in foreign countries under the ATS. But of course, more lawsuits were still brought because of this paragraph, leaving open the possibility of suing in the US. That takes us to 2018 and Jesner versus Arab Bank. This was a case against a foreign corporation, a foreign bank sued in the US for activities that had occurred in the West Bank. And the court, in a 5-4 decision, Justice Kennedy set out a rule that essentially you can't bring a case under the ATS against a foreign corporation in the US. Justice Sotomayor wrote a dissent and said, look, you've already got this presumption against extraterritorial application of the statute. The court, she said, is using a sledgehammer to crack a nut. I thought that was an interesting thing to say. She thought that the presumption was enough and that to say that you can't sue foreign corporations went too far. And that left us, where we were in 2018. And so where were we? No new causes of action created by the ATS. You need to have some common law cause of action that involves clear violation of an international law norm, presumption against extraterritorial application. And what that means is, as a general matter, you can't sue a foreign corporation in the US under the ATS. Well, these cases, Nestle and Cargill, involve US corporations with, I'm sure you're familiar, who were sued under the Alien Tort Statute in the US for conduct that occurred abroad. In particular, the case involved chocolate, cocoa beans, the allegations in the complaints. And this case is at the complaint stage, so these allegations haven't been proven. The allegations brought by unnamed foreign individuals, the does in both cases, say that there was forced child labor at cocoa farms in the Ivory Coast, and that Cargill and Nestle bought those cocoa beans and on occasion sent individuals down to look at operations in the Ivory Coast. And as a result of that, Nestle and Cargill can be held liable in US courts for things that the farmers did in forcing child labor in the Ivory Coast. I should note that there are a lot of intricacies with the complaint in terms of the specific pleadings. Certainly in terms of things that happened in the Ivory Coast, it's not clear at all that the pleading actually links Nestle and Cargill to any of the places where there was allegedly forced child labor. But either way, so this case is still at the pleading stage. It was brought 15 years ago, so that's a long time to be at the pleading stage. It's gone back and forth from the district court to the Ninth Circuit. The Ninth Circuit finally allowed the claims to proceed past the pleading stage. Nestle and Cargill sought review from the US Supreme Court. The government came in on their side and said, you should grant review, and also asked the court to add a question, which I'll discuss in a minute, and the Supreme Court granted review. The cases have only been half briefed, so only the Nestle and Cargill side have been briefed so far. They're not going to be argued until December 1st. So let's get into what are the arguments in these cases. Well, there's a big overriding argument that both the government make and Nestle and Cargill make, which is that you just can't sue a US corporation under the Alien Tort Statute, that there's not an international law norm that gives a cause of action here, and that there are pretty serious foreign policy concerns that are implicated by opening the US courts to claims like this. The US government strongly makes that argument and also suggests that there are separation of powers concerns with allowing a US corporation to be held liable under the ATS. I should note that this is pretty interesting because it's not the position that the US government has taken in prior cases, this argument that a US corporation can't be liable under the ATS. So that, I think, from the Nestle and Cargill's and the government's perspective would be the big win, essentially shutting the door on claims against US corporations under the Alien Tort Statute. But there are much more narrow ways that the court could resolve the case. One narrow way that the US government suggested is that that the court could hold that there's no aiding and abetting liability under the Alien Tort Statute. Now, that is what the claims are against Nestle and Cargill. Will the Supreme Court really consider that argument? Hard to say, because when the government filed its brief at the cert stage, it asked the Supreme Court to add a question about whether there's aiding and abetting liability, and the court didn't add the question, and so then the government just brought it up again in its brief anyway. Will it get any traction? Maybe. This is a case in which there have been so many different opinions by different justices over the past 20 years that getting a fair number of different theories out there isn't the worst idea, just because there haven't been consensus views on a lot of questions. And then there is, of course, the narrowest way to resolve the case, which is, the question in this case is, have the plaintiffs adequately pleaded a violation of an international law norm cognizable under the ATS? And Nestle and Cargill say, no, there's a presumption against extraterritoriality. Everything that's alleged in the complaints are things that happened in the Ivory Coast that farmers did in terms of forced child labor. The only allegation about things that happened in the US are that Nestle and Cargill generally directed their operations in buying cocoa from the US. That just can't be enough to actually make out a claim for aiding and abetting. And I think there's a slight, perhaps, bit of disagreement between the rules that Nestle urges and Cargill urges in terms of where is the place you're supposed to be looking to see if there's an extraterritorial application? Is it the place of the primary violation versus the place of injury? That might be that dispute might be beside the point, because I think those are the same in this case. So this case is interesting to me for a couple of reasons. One, these issues have been before the court, it seems like forever. I guess it's basically since the beginning of my legal career in Washington, the court's been grappling with the Alien Tort Statute and what to do about it. So it's, I think some people thought that this might be a case in which the court might just shut the door on liability against corporations under the Alien Tort Statute. But the second reason this case is interesting is because it seems to me like it really is one in which the fact that Justice Ginsburg is no longer on the court and that the chief might be seeking for consensus in some of the cases, that might lead the court to take a more narrow approach, even though there are perhaps some justices on the court who might like to take a broad approach, putting in place, for example, a clear rule that US corporations couldn't be liable under the ATS. So I think it'll be an interesting case to watch. And obviously I'm excited to hear what the panel has to say, especially those who've been living through arguing these decisions.
So anyone else who wants to comment on the ATS? Not anyone. So just before we turn to the panel, let me ask this question to you, Nicole. You know, in Sosa, which I think Paul argued, the court said, you know, we can have claims of human rights abuses. And since then, we've had claims of human rights abuses, one after the other. And the court, time after time after time, has said, no, we're not going to entertain this claim. Obviously, on a narrower, each time on a narrower ground than just overruling Sosa, which said you could make claims like this. Is there any chance the court will finally just decide to end this charade?
I actually thought there was a pretty good chance, at least up until recently, just because there wasn't much narrowing that was really left. You know, you have the case about presumption of extraterritorial, then you have a case against a foreign corporation. You know, this domestic corporation case really seemed to tee up the issues, but I guess I have a hard time believing that the court will reach out and kind of shut the door now, just because I just have this sense that the chief will try to find a narrower view on which to decide the case. But it is interesting, I mean, especially from the perspective of, you know, the dissenters along with Justice Sotomayor and Jesner, you know, they say, like, these are horrible, horrible allegations. And you know, to the majority keep saying that these claims are available. Like, well, when are they going to be available? So I feel like Justice Sotomayor has made the same point you have, Herb.
I mean, if it's not when there's allegations of slavery, it's hard to see when it would be.
I mean, all of the allegations in these cases are terrible. You've got like terrorism in one of them, you know, child slavery in another. They're terrible. So I don't know, but I feel like Paul just unmuted, so he might have something to say here.
Yeah, I mean, I was going to say, you know, even before Irv asked this question, you know, I do think that it's a little hard for me to see the corporate defendants, you know, not prevailing on some ground in this case. Because, you know, I do think that you know, if the court were to decide on aiding and abetting, you know, it seems pretty clear that, you know, in light of Sosa, you have something kind of like an implied cause of action here. It's a little bit different, but that's basically what it is. And the Supreme Court has already said that you don't get aiding and abetting liability under an implied cause of action in the Central Bank of Denver case. And, you know, I got to think that there are at least five justices that have some sympathy with that result. I also think, you know, I was involved in the Arab Bank case as well. And, you know, that was one of those cases where we argued that there would be no liability for a corporate entity. And that was one of those classic cases where the court accepted essentially all of our arguments as to why a corporate defendant wasn't the proper defendant, but then just limited it to foreign defendants, even though most of the logic would apply to a U.S. corporation as well. So I do feel like there is a lot of different ways the court could rule in favor of the defendants, and I find it a little hard to think that, you know, this is a case where they're going to finally sort of give a green light to a plaintiff's case under the statute. But, you know, all of this makes me wonder, maybe it's not this case, but, you know, as much as the chief doesn't like overruling cases and all of that, I mean, you know, he is very concerned about, you know, the kind of the reputation of the court and the courts more generally. And, you know, I'm not sure the courts look great if time after time they, you know, consider these horrific allegations and say, no, not this one. So, you know, it may be one where, you know, that, you know, we argued all the way back in Sosa, we argued you really should just, you know, and let, you know, this maybe if you have piracy, okay, but otherwise, you know, you just really should shut the door definitively on these actions. And, you know, the line from Justice Souter's opinion that, you know, was, you know, beautifully Souter-esque, but it's kind of, you know, kept, you know, appellate lawyers busy for a good 15 years, is we're going to keep the door ajar to these claims subject to vigilant doorkeeping. And, you know, I wouldn't be surprised if maybe not in this case, but the next case, the chief and the rest of the conservatives say, we just want to get out of the business of doorkeeping. This isn't a great function for the courts to be doorkeeping. We don't cover ourselves with glory. We keep saying no to these awful things. And if Congress wants to pass some new statutes along the lines of the Torture Victim Protection Act, and provide, causes of action, statute of limitations, exhaustion rules, and all the other things, great. We'll get back in the business based on these new statutes, but we're not going to, continue to sort of play around with this 33-word statute passed in 1789.
Okay, so
if the court were doing that, it's not like it's, necessarily abdicating its responsibility or saying to U.S. corporations, like, do whatever you want around the world. I mean, this case, one of the reasons, that I mentioned Paul's and Don's involvement is because the U.S. government's views have been so important and the kind of separation of powers concerns have been so important. And so it would be the court saying, like, look, these are really foreign relations issues, things handled by the other branches of government. And that would be something that, would be entirely appropriate for the court to potentially say.
okay, so any questions from the press on this one?
There are no pending questions.
Okay, so Don and Van Buren versus U.S.
Yeah, this is an interesting little criminal case, Van Buren versus United States. It arises under the Computer Fraud and Abuse Act. I'm going to read the statutory text first because it's relevant. It makes it a crime to access a computer without authorization or to exceed authorized access and to thereby obtain information from the computer. And the statute defines what it means to exceed authorized access, which is to access a computer with authorization and then use your access to obtain or alter information in the computer that the user is not entitled to obtain. And the case arises in a kind of a sleazy factual scenario. A police officer in Georgia who, as part of his official responsibilities, has access to the Georgia Crime Information Center computer system and database. This officer develops a relationship with a kind of a low-life criminal who spends a lot of time consorting with prostitutes and hanging out with exotic dancers. And the officer is in a bit of financial trouble, and so he essentially leans on this lowlife for money. And the guy responds badly to this, actually confesses it in confession to his priest. Priest finds a way to get him to find his way to appropriate officials in state law enforcement, who then bring the FBI in. The FBI organizes a sting operation in which the FBI has this guy go back to the officer and say, look, there's this exotic dancer. I want to go out with her. I want to make sure she's not an undercover officer. Can you find that out for me? He goes into the computer database, and if you do, I'll pay you some money. He goes into the computer database and checks her out and gets arrested for this, and then he gets charged under the statute I just described. On the one hand, it's an interesting case in a lot of ways, I think. On the one hand, sounds like what he did was to use his access that he was authorized to have to obtain information in the computer system that he wasn't entitled to obtain. On the other hand, I suppose you could say that, no, he was entitled to obtain that information. He just wasn't entitled to obtain it for this criminal purpose. And that's actually what the statutory construction fight is about. The government charged him, convicted him, and is defending the conviction. The argument that Van Buren's making, his lawyers are making, is essentially, look, they're trying to put this case into the stream of criminal cases that the court has decided over the last several years, cases like Bond and cases like Yates and cases like the Bridgegate case Kelly last term. And this is just another example of federal prosecutors wildly overcharging and relying on wildly expansive interpretations of federal criminal law. And if this interpretation of the statute holds up, then virtually everybody is violating the Computer Fraud and Abuse Act with regularity, because if you are on your office computer network at work and you decide you're going to go shopping on Amazon, you're obtaining information probably in a way that is not consistent with the authorization that you have to use that system. And then even worse, every time you agree without reading to terms of service on anybody's website, if you then act in a manner that's inconsistent with the terms of service and obtain information, that you violated this act. I think that the reason I think the case has some significance, and that in addition to it being another one of these cases like the Bridgegate case about very aggressive use of federal criminal law, is that there are actually a lot of cases kicking around out there under the Computer Fraud and Abuse Act in which companies use the act to try to defend themselves from incursions from data scrapers and others. And there have been a lot of lower court decisions, a couple of Court of Appeals decisions, one of which I've been involved in, that pose pretty significant issues. And so I think, my own sense of it is that Van Buren's got a good argument here, that there is text, you can interpret the text in a manner that allows him to win, saying, well, yeah, he had access, he had authorization to obtain the information he obtained, maybe not for this illegal purpose, but he had authorization to obtain this information. And that provides a limiting principle that cuts off all of the potentially wildly expansive applications of the statute that Van Buren's identified. And I do think, given this trend that we've seen in cases, Bond, Yates, Bridgegate, et cetera, it seems like this is going to be another case in which the court decides that the United States has gone too far.
Anyone else on this one?
Yeah, I'll jump in, Irv, on this one. I agree with Don's analysis of the case, and with the kind of just the general framing. This feels like the next one in those line of cases where the government gets beat up. I think, one thing that's interesting is the Attorney General gave a fairly controversial speech a few days ago at Hillsdale College, where he talked about a number of very controversial things. But one big section of the speech was devoted to talking about sort of the overcharging, overcriminalization, and prosecutors pushing the envelope on substantive criminal law. He used some colorful language. He was talking about hyper-aggressive extensions of the criminal law, and said that DOJ needs to be disciplined about what legal theories we will bless. And I know when I was in the SG's office, Don, you were very attuned to this, and you and Michael Dreeben were both trying to kind of make the pitch to U.S. attorneys' offices to kind of think hard about certain types of cases, because they might not ultimately be defensible as they move up the appellate chain. But obviously, the SG's office is not really in charge of the initial charging decision. So I think this is a continuing problem. It seems to cut across administrations. It doesn't have a political slant one side or the other, but I just wonder if either you or Paul, especially having sat in the SG's chair, like what can be done? Even the Attorney General seems upset about this, and yet, his SG was up there arguing for a very aggressive interpretation in Kelly, and they're going to be arguing for a very aggressive interpretation of the law here. So what can kind of be done to walk this back a little bit? So
I was a total failure, and I did care a lot about this. My searing experience being on the other end of Paul in the Bond case, and watching others, including you, Roman, in these really difficult situations in Yates, for example. I really felt like we were draining away our credibility by trying to defend these prosecutions. But because the charging decisions are made on a decentralized basis, I thought all I could do was try to evangelize. And so I went out, did a lot of visits with U.S. attorneys' offices, spoke down at the training center. And then one year I did a talk for the U.S. attorneys when they were in Maine Justice for their annual gathering. And I, for the one and only time in my life, used PowerPoint to put up PowerPoint slides of the questions that the court was asking about the charging decisions in Bond and Yates. And in particular, you'll remember this, Roman, Justice Scalia's question in the Yates case, the Fish case, was this the same prosecutor who charged Mrs. Bond? Trying to make the point that, you're squandering our credibility here and this is going to come back to haunt us. And all the U.S. attorneys to a person sat there with their arms folded like this, and they were having none of it. And when I talked to them afterwards, the reason they gave was this. They said, look, this is a system that runs on plea bargains. 96%, 98% of cases are resolved on pleas. And if we're going to be effective in the plea bargain process, we've got to charge aggressively. And if every now and then a moron fails to take a plea and the case goes forward and the charges, the jury convicts and the charges get upheld on appeal and you lose in the Supreme Court, well, that's just the price of doing business, big deal. And so I think it's a very difficult nut to crack. I do. I think, I'd like it to be different, but I think it's a very difficult nut to crack.
On a completely different topic, one of the reasons that this case is interesting to me is that there are cases from time to time where you find out kind of the justice's own personal experience with technology and how that affects their decision making. You remember this from the Apple antitrust case where, I think Justice Kagan was very surprised to hear that she wasn't a direct purchaser of an app on, the iPhone App Store. And so you kind of wonder what kind of questions they're going to be asking about terms and conditions, and do people really read that, and do people really follow that? And it'll be, informed by their own experience, which I always find very interesting.
Questions from the press?
We have a question from Evrat Livni from New York Times Deal Book. Evrat, would you like to ask your question live? We've unmuted you.
Hi, sorry. I'm wondering how is it possible to have a criminal statute that doesn't include intent? Would it even be possible to find strict liability? I mean, either strict liability or a purpose. How could we possibly not consider the illegal purpose for which the guy logged onto the database? Wouldn't that always be an element in a criminal case?
So you're right about that. I neglected to say you have to do this to violate the statute. You have to do it knowingly. And so one thing the government argues is that the requirement to prove that criminal state of mind is a way to narrow the scope of the statute, that if people inadvertently stumble into obtaining information that they're not authorized to obtain, that's not a crime. It's only when you do it knowingly. We'll see whether that argument works, but I think that is, you're right to point that out, and that is a feature of the statute.
Thank you.
No pending questions.
Okay, so then Paul Smith on election law cases.
Thanks, Irv. Unlike the other panelists, I'm not talking about a case currently on the docket, just in the realm of speculation, so I'll keep it brief. But it does seem that there's a number of different ways in which cases filed in the future about the election could end up in the Supreme Court this year. And part of that is that there's so many cases people are already filing. Everybody's kind of on a hair trigger from both sides of the aisle filing litigation this year about the election. And I would kind of put it into four categories of how cases could get to the Supreme Court. One is that we might have a reprise right before the election of the Wisconsin primary case, RNC versus DNC, that went up on the question of adjusting deadlines for absentee balloting when the state was very tardy in distributing ballots and there was a problem of people being unable to vote. I think that there's been a lot of litigation about that already in a bunch of places, some of it dismissed as unripe. I think we may be seeing things like that happening well into October, asking for changes in deadlines, maybe using, allowing people to mail things on election day rather than have them received. The court seems to be not all that happy with federal courts meddling in this area right before the election, so they may very well get involved and push back. The next category would be if we have what we were most worried about before COVID about the election, which was some kind of disruption on election day, either caused by nefarious foreign actors or just by a hurricane or something. if the grid went down in some part of the state, or the registration records disappear in some computer in some part of the state, or we have a hurricane in Miami, there will be all sorts of complicated questions potentially about what kind of relief to give, if any, particularly in a situation where that part of the state would have had very distinctive voting patterns, might change the outcome in the state, that in turn might change the outcome nationally. People would have to ask questions like, well, who gets to continue voting and for how long? Is it the whole state or just the part of the state that was disrupted? And I can certainly imagine those issues ending up in the Supreme Court very quickly. The third area is the one that's sort of being telegraphed by the president, who yesterday said we need 9 justices to be on the court after the election because we're going to have litigation about all these fraudulent mailed-in ballots. I think what people worry about is we're going to have a situation where the president is perceived as ahead on election night, but there are lots of ballots to count in key determinative states, and there'll be some effort to try to shut down the counting of the mailed-in ballots, which could, in a place like Wisconsin or Michigan or Pennsylvania, take days or even weeks. And I don't know what that effort would be. There may not be one ultimately, but if there were, it might be some kind of lawsuit trying to shut down the count. Or it might be some more exotic thing like going to the legislature and asking them to declare a winner. And so either way that goes, I think you have the prospect of all sorts of litigation filed federal state court that could end up confronting the justices with the question of whether or not the counting process should continue, or the outcome of the counting process should be validated as opposed to some legislative incursion into it to try to declare a winner. And then finally, given those kinds of exotic scenarios, you could end up with fights in Congress in January about which votes to count from which states, which electoral votes to count. You might even have 2 sets of votes from the same state. And that process occurs in a very convoluted manner under a statute from the 1880s called the Electoral Account Act, which is full of ambiguities and confusion, and could produce a situation under the right conditions where the 2 houses of Congress disagree about which electoral votes to count. And so we could even see some kind of emergency Supreme Court appeal in January as we're heading toward the inauguration date, the end of the current presidential term. And we don't have a clear resolution. This is the repeat of the 1876 scenario where it looked like there might be 2 inaugurations on inauguration day. Now, all of this stuff makes me sound a little alarmist. I'm glad to say I don't actually predict any of this stuff, but it's certainly all out there as possibilities given the way this election is being set up as a kind of do or die for both sides, and the constant refrain about claims of fraud in mail voting, which seem like they're calculated to set up the prospect of some kind of extended post-election squabble that, ultimately there may not be anybody else but the justices to handle it. The changes in the composition of the court we're about to see seem likely to be significant potentially here, where the Chief Justice used to be in control and now no longer will be in the same way. So we'll have to see how this all plays out.
Thanks, Paul. Anybody else on the election law prospects?
Irv, I'd only make one small discrete point to add to Paul's final scenario, which is it appears that Chief Justice Roberts, to the extent he remains the decisive vote or an important vote, he seems to, in this area, be wanting to be very deferential to state officials and to existing state laws and norms, which might be a nice touchstone in many of the cases Paul describes. But the hard cases will be in. We hope these won't happen, and they ought not to happen. But if there's cases in which there's states with a Republican legislature and a Democratic governor, you have the 2 parts of the political branches from a state at odds with one another on what the slate should be, for instance. then he has to decide between the two state political branches, and that not quite as easy.
Anybody else? Questions from the press?
No additional questions are coming in.
Okay, so thanks everybody for participating in this, and that's it for today.
Thanks, Herb. Thanks, everyone.
Hi, everyone.